It has been elaborated in another video that for Islamic law to grow and develop in the modern age, to serve the needs of the Muslim Ummah or community, it must re-emerge at the international level. At the international level, it will be free of the shackles imposed on it by the state, which is not willing to grant it adequate freedom to develop, for it might view such development as hostile and even detrimental to its security. It was shown elsewhere that the declarations, conventions, and protocols issued by the United Nations have not adopted a single principle or rule of Islamic law. The principles of Islamic law are also not acknowledged in the other sources of international law listed in Article 38 of the Statute for the Permanent Court of International Justice. These other sources are international customs, principles, and judicial decisions and teachings. All these revolve around the Anglo-European American systems and civilizations. Whenever Muslim countries try to make a reservation based on Islamic law, the other states, following the procedure at the United Nations, say that you cannot rely on domestic law for making reservations. In simple words, it means if you wish to raise such objections, just stay out. Thus, for example, Muslim states raise some objections to the Convention on the Rights of the Child, saying, among other things, that adoption was not allowed in Islam. They were forced to back down, and as eyewash, a rule for fosterage called kefalat in Egyptian law was referred to without having any bearing on the CRC. The rule for kefalat is not applied this way in Islamic law as it is applied in Egyptian law. The crux of the matter is that the structure of binding and non-binding sources of international law, as erected by the United Nations, is designed to keep out Islamic law because that is the only legal tradition besides civil law and common law. We also stated that international law exists for facilitating trade in a peaceful manner and for sharing the resources of earth with justice. One main purpose is the security of international transactions. This goal is so important that if business people find the rules set by nation states or by the United Nations to be too restrictive, they can brush aside those rules and follow the rules that they agree upon. When a dispute arises out of their chosen rules, they usually provide that the matter will be taken to arbitration in tribunals of their choice. It is only as a last resort that the matter may be taken to domestic tribunals for enforcement, where it will be settled according to the rules of private international law. There are some other matters too where domestic institutions come into play, like the carriage of goods and payment systems. It is generally acknowledged that one of the most remarkable developments on the contemporary legal scene is the emergence of an autonomous law of private international trade, which is breaking through the barriers of national legal systems and is assuming a universal character. This autonomous body of law provides more effective solutions to the problems of international trade. The result is that it is increasingly replacing the conflict of laws approach that applies one of the many national systems of law, when this municipal or national system may be inadequate in the changed circumstances of modern international trade. The success of this autonomous body of law depends upon two things. The first is the elective character of the law. The elective nature of the law of international trade exists because this branch of law is founded on the principle of the autonomy of the parties' wills. Such relative freedom in tailoring contracts enables the parties to overcome the peculiarities of the various municipal systems of law and to adopt rules more suitable to the requirements of their individual relationship. This new autonomous law is being expressed in model contracts, standard clauses, general terms of delivery, commercial customs, and trade usages. Most of the model contracts are being issued by the International Chamber of Commerce, which also issues the language that traders speak to make contracts, called Incoterms. The second is the effective support for and the growing use of Arbitration in trade disputes. Experience has shown, however, that for the autonomous will of the party to a contract to be considered effective, it has to be complemented by an arbitration agreement. Parties willing to develop rules to govern their relationship apart from municipal laws do not wish to find themselves subject to municipal courts when disputes arise. They prefer arbitral tribunals where customs, usages, and business practices are more readily taken into account. The principles of this autonomous law have been issued by UNIDROIT, which is an institute that came into existence at the time of the League of Nations, but is not a United Nations body. These principles are gradually gaining ground. The United Nations body that is occupied with a similar task of creating uniform commercial law is called the United Nations Commission on International Trade Law, which has issued the Convention on the Sale of Goods, called the Contracts for the International Sale of Goods. But that is a United Nations binding document. It has been ratified by more than 60 states so far and is gaining more ground in Europe. Our purpose here is only to indicate the existence of an autonomous law at the international level, which is a law that individual concerns may choose for themselves and support with a system of arbitration. The main purpose of this discussion is to show that Islamic law has been an autonomous law functioning at the international level since its birth. It has been indicated in different sources that the qazis operated more like arbitration tribunals. It was only where the schools of law had imposed a duty upon the rulers that the public law was applied by these judges. The rulers, too, were free to choose the school that they liked for this purpose. That is, for adopting the rules for hudud and qisas, for example. In the light of this past history, what we mean by the emergence of Islamic law at the international level as an autonomous law is the following. First, Islamic law must grow at the international level as an autonomous law free from the constraints and needs of modern states. Second, it should develop and grow with the aim of providing solutions to modern issues and problems. Third, Islamic law should develop in a manner that it can be adopted and adapted by states if they so wish. Fourth, Islamic law should grow at the international level in all those areas that can employ arbitral tribunals for the resolution of problems. Fifth, Islamic law should grow at the international level with the active participation of those who are interested in its development and who wish to contribute to its growth. Sixth, in its development and growth, the law should employ the uniform and latest methodology that was developed by the ancestors. And seventh, Islamic law must grow into a uniform law acceptable to all Muslim, at least in areas where that is possible, leaving other areas to be followed according to the various schools that individuals choose for themselves. What is of crucial significance is that the law must develop free of all school bias. Further, this law must not focus on personalities unless these are the earlier imams, preferably those of the 6th century Hijra and earlier. The entire focus should be on what the rule is and what the evidence is on which it is based, along with the accompanying legal reasoning. We may now briefly list a few important areas that belong to the core law of Islam that contain measures that are likely to provide substantial benefit to Muslims all over the world. The priorities may, however, be changed if the Muslims so decide. The first area is that of Zakaat and Zakaat. The law of Zakaat should be developed from an international perspective as a global system in the service of the Muslim Ummah. The law of voluntary charity should also be developed for the help of mankind in general. Some of the major questions to be asked must be whether Zakat collected can be moved across the entire expanse of the earth to fight hunger and poverty in the Muslim world. It should also be explored as to what kind of financial or other institution will perform the function of distribution of zakat as well as Zakaat. Institutions trying to perform these functions already must show that they are performing functions according to an acceptable uniform zakat law. These institutions should also make their affairs more transparent. The second area is that of Hajj and Umrah. The rules of Hajj and Umrah should be refined and expanded in light of modern issues faced by worshippers. Other issues from the other acts of worship may also be included, especially those related to timings and so on. The third area is that of developments in the medical field and the ruling of Islamic law. Scholars of Islamic law keep on addressing modern developments in the field of medicine. However, this entire research needs to be restated in the form of a law. The most important developments may be taken up first. The fourth area is that of modern methods of food creation and distribution. This is a crucial area that needs immediate attention, especially in the light of the growth and use of genetically modified foods. The rules must lay down the requirements for the food industry, halal food, and so on. Medicines and drugs using prohibited matter may be included in this area. These matters should not be left to the countries where the relevant industries are based. The fifth area is that of rules and recommendations for countries where discrimination against Muslims may exist. The discrimination contemplated here is based on clothing, acts of worship and religious practices, religious education, or the other preferences of the concerned nations. The genocide of Muslim may also be included under this head if deemed necessary. Most of these issues will arise where Muslims are in a minority. The sixth area is that of Islamic commercial law and arbitration. This is perhaps the most important area. Initially, the UNIDROIT principles and the contracts for the international sale of goods will first be analyzed from the Islamic perspective so as to find common ground with the rest of the world. In other words, an attempt will be made to Islamize these principles so that the United Nations realizes the requirements of Muslims living in this world who will be rapidly moving towards a majority mark in world population. The mechanism for setting up and implementing arbitration tribunals will also be explored. Efforts will also be needed to analyze the payment systems so as to identify the changes that may be needed from the Islamic perspective. To this may be added the needs of banking and finance, if deemed necessary, as the mechanism set up will provide an unbiased and impartial analysis. The seventh area is that of family law and associated tribunals. Matters of family law will be studied to develop a uniform law that can be followed by Muslims all over the world. Tribunals may be set up for meeting the dispute resolution needs of this vital area. Gradually, Islamic law must step into every area that is being addressed by the United Nations and give its ruling and analysis. Thus, for example, it can start by issuing the Islamic nations and human rights, or even begin examining the Human Rights Declaration to see what needs to be changed. In either case, the effort must identify the principles that need to be recognized by the United Nations. If the current human rights are claimed to be universal and indivisible, they must incorporate Islamic principles. It may be pointed out here that Islamic principles are equally universal and indivisible. The declaration may or may not rely on the Cairo Declaration. Declarations should be issued whenever and wherever it is felt that the United Nations is ignoring certain fundamental principles of Islamic law. Declarations will be needed for the political and economic rights as well as for the rights of women and children. The following organizations and institutions may be contemplated for future action: International Zakaat and Zakaat Organization, Islamic Court of International Arbitration, International Institute for Uniform Islamic Commercial Law, Islamic Trade Organization, Islamic Food and Drug Organization, Islamic Labor Organization for Migrant Populations, International Islamic Criminal Court, Islamic Human Rights Organization, and Islamic Financial Organization. It is suggested that universities in the Muslim world, especially those departments that deal with law and international relations, should encourage research in the above areas. There has been too much occupation with armed conflict and international humanitarian law. Students must open their minds to other vital areas to see where the Muslims of the world stand on such issues. For resolving the differences between different schools of law, the first question that will come to mind for most is about the multiple opinions on an issue within a school, and many more when the scope is expanded to include other schools. What then will the people follow? The response is that, as the law is not being enforced through the state and its enforcement mechanism, much depends on what the people will choose for themselves. In the case of acts of worship, people will follow the school they are following now. Any new issue taken up will be one that the school has not addressed. In such a case, following the rule in the new issue should not be a problem. For example, many new issues pertaining to purification, prayers, fasting, Hajj, and so on have already been addressed, even those that have arisen in the modern times. In the case of Zakaat, the amount to be paid and other details may be the same as those addressed by the schools. The new issues will pertain to the collection and distribution from the international level and the possibility of permitting this. In the case of marriage and divorce, people will continue to follow what the schools have said. Many new issues arising due to the domicile and school of the parties to a marriage contract are not new issues and have already been addressed by the schools. As for the new issues in this area, these will be those that have not been addressed by the schools and will have no ruling within individual schools. It will be easy to follow the new rulings on new issues. As far as international commercial law is concerned, it is only some fundamental principles that are of vital significance. There is not much difference among the schools between these fundamentals. The details developed by the jurists will be given new shape in any case in accordance with the needs of modern commerce, trade, and financial transactions. The bulk of the law will have to be developed in the light of the fundamentals of Islamic law, according to the new methodology that has been elaborated in our new book called The Methodology of Ijtihad, Old and New, Comparative Jurisprudence 2021. These will be issues on which there is no ruling in the schools. The above description shows that there is no serious issue about differing views of jurists and schools. The law at the international level will be much more flexible and vibrant, as will be explained later.